So with that, again, I want to welcome you here. In particular, I want to introduce Sandy Mayson, one of the inaugural class of Quattrone Center Research Fellows, who will moderate our first panel on risk assessment tools. We couldn't be happier to have Sandy. She's a criminal and constitutional law expert with a focus on risk prediction and preventive restraint, so she's absolutely a perfect person to moderate this panel. She comes to us having spent several years at the Orleans Public Defenders. She was a Furman Fellow at New York University School of Law. She has 2 federal clerkships, one at the federal district level with Judge Phil Restrepo, who has since been promoted to the Third Circuit, and one with Judge Sloviter when she was on the Third Circuit. She has a BA summa cum laude from Yale before kind of stumbling a bit and only getting her JD at NYU Law magna cum laude. What can you do? So with that, Sandy, take it away.
Unexpectedly lengthy introduction. Good morning, everyone. Thank you for being here first thing in the morning. It's a good thing you are, because we have a fantastic panel to kick off this symposium. This panel, for those of you who know the reference, is the Minority Report panel. It is about how the criminal justice system predicts who is likely to commit future crime. Specifically, we'll be talking about new technologies of prediction or forecasting. I'll use both those terms, the opportunities they present, and the fascinating legal and moral questions they raise. Now, there are actually, as John said, 2 panels on prediction this morning. Predictive policing is up next. So the scope of this panel is on prediction or risk assessment after arrest. When does risk assessment happen in the course of a criminal case? It happens at many points along the way. Risk assessment informs pretrial custody determinations, charging decisions, plea negotiations, sentencing decisions, probation tactics, prison security classification, and parole decisions at the back end. Now, that's been true for a long time. But the reason we have a panel on risk assessment in this symposium is that our methods of risk assessment are undergoing a fundamental shift. The criminal justice system is turning to actuarial risk assessment. Now, that is not entirely new. Parole boards have been using actuarial instruments since the 1930s. But 2 things are new. The first is the fact that so many actors in the criminal system are deploying actuarial risk assessment at so many stages in the process. So 2 major examples are the ongoing pretrial reform movement, which aspires to deploy actuarial risk assessment at the pretrial stage, and the evidence-based sentencing movement, which deploys actuarial risk assessment for purposes of sentencing. The second thing that is new is that our methods of risk assessment are rapidly improving. So there are 2 basic methods of risk assessment that the criminal justice system deploys. The first is the use of what's called a checklist instrument. The second is the use of a machine learning procedure, a machine learned algorithm. We are getting much better at both. Our access to big data is making us much better at both. And our new prediction abilities present opportunities and challenges we've never faced before. Now, before we move on to our substantive discussion of those opportunities and challenges, I want to clarify the 3 kinds of questions or objections we might raise about actuarial risk assessment. If I have an objection to actuarial risk assessment in the criminal process, it might be an objection to 3 things. I might be objecting to, number 1, the fact that we have decided to engage in prediction in the first place. Number 2, the methodology of prediction, or some aspect of the methodology. Or number 3, the response to the prediction. So as we have this conversation, I want us to be thinking throughout, if we're talking about some issue, are we talking about a concern with the fact of prediction, the methodology of prediction, or the state's response to a given set of predictions? The format of this panel is going to be 3 short presentations by our panelists, followed by some moderated discussion, and then audience Q&A at the end, so think of good questions. And now I'd like to introduce our fantastic panelists. We have, at far right, Richard Burke, professor of criminology and statistics here at the University of Pennsylvania. Richard's work in applied statistics transcends the conceptual and technical expertise of most people at this university. So it is fascinating and impressive work. Richard has spearheaded the development of machine learning procedures for forecasting in criminal justice, and he will educate us about the technical mechanics of different methods of forecasting. At center is Ezekiel Edwards, the director of the ACLU's National Criminal Law Reform Project. Excuse me. As director of the Criminal Law Reform Project, Zeke has pursued an ambitious agenda of strategic litigation and policy advocacy aimed at ending mass incarceration and promoting racial justice, among other things. So Zeke will present an expert perspective on the implications of actuarial risk assessment technologies for racial justice and civil liberties. And then at far left is Sonia Starr, professor at University of Michigan Law School. Sonia has accomplished the rare feat of combining deep expertise in legal doctrine and theory with deep expertise in quantitative methods, and has become one of the most prominent critics of actuarial risk assessment in the criminal justice process, particularly in sentencing. Her article in the 2014 Stanford Law Review, Evidence-Based Sentencing and the Scientific Rationalization of Discrimination, mounts a set of powerful constitutional critiques that she'll be expanding on here today. So with that.